I'd like to welcome everybody to It's Time to Get Your You Know What Together. Here we'll discuss everything from estate planning to how to avoid probate administration, everything in between. Housekeeping, keep your microphone muted. If you have a question, please type it in the chat and I'll be happy to engage with you. I won't be announcing who's asking the question just for privacy purposes. So if you have a secret question you'd like to ask, please feel free to do that. And at the end of the program, we'll open up for Q&A. Let me introduce to you Samantha Fitzgerald, Sam to me, sorry. Samantha is an attorney in Plantation and her firm is 100% focused on estate planning and probate and trust administration. She's been practicing for over 20 years and she's a CPA and has her LLM in tax. And I'm your host and moderator, Bianca Morales. I will be here with you through the duration. I'm a business development coach and career transition consultant and coach. I bring 37 years of experience to the table with concentration in law firms and working with attorneys with the ability to help any company achieve and get to the next level. So welcome everybody. We're so excited you're here. We are going to explore the topic of homestead. Like, how exciting is that? Not, but here we are to talk about it. So, to clarify everything, Samantha, what is homestead?
So first, I'd just like to say thank you for everybody for coming and welcome. It's really exciting to have everybody here. And personally, I think homestead is super interesting. If you knew it like I did, you would think it was too, because it is so tricky. It's one of our really, really tricky assets in Florida. Most people don't understand it. Most lawyers don't really understand it. It has lots of rules. So in a very simplistic explanation, homestead is your primary residence. It's where you live. You can only have one primary of anything because by definition, it's something you do more than other things. So it's your home. It's your house, your condo, your townhouse. It can get a little bit more complicated when we're talking about like co-ops and maybe mobile homes and stuff like that. But in general, it's your primary residence and your home. And Florida has something very, very special. We have significant creditor protection for your homestead. So everybody probably remembers O.J. Simpson moved to Florida specifically for our enormous exemptions when he was filing bankruptcy, and homestead is one of them. It's a really, really fantastic benefit, but with that benefit comes a lot of rules and restrictions. So basically the answer to the question is it's your primary residence.
Okay, well, thank you for clarifying that for anybody that has investment properties, okay? But let's get into some juicy stuff, all right? I'm on my second marriage, is a question from someone. I'm on my second marriage and my new spouse isn't on the title of my home. I want to leave it to my kids. Can I do that?
Nope. So we have, as I said, restrictions on what you can and can't do with your homestead. So your spouse has significant rights to your homestead. You can be married for 1 minute and your spouse has rights. Automatically, if you die, your spouse gets a life estate in your homestead. So what's a life estate? Nobody ever knows what that term means. Basically, it means your spouse can live there for the rest of his or her life, or they can rent it out and collect the rents. Basically, they get to utilize the property for as long as they are alive. When they die, the balance, or what we call the remainder, passes to the owner or the decedent's children. So if you were to try to leave your property to your children while you are married, you are married, it will be an invalid devise, and it just simply fails. And then the property would pass as if you didn't have any documents, no will or a trust. So you can't just do whatever you want with your property. The same goes, while you're alive. If you try to sell your homestead or get a mortgage or refinance a mortgage, you can't do any of that stuff without your spouse's consent, even if they're not on the title of the property. So there's restrictions on your homestead in relation to your spouse, both while you're alive and after you pass.
Well, I have a question for you then. So what if you bought the property before you got married? As soon as you get married, if it's homestead, they have rights to it?
Yep. Which is different from divorce. So there are different rules. There are premarital assets when you marry and divorce, but the same is not true for death. Death is based upon what do you own when you die, and are you married or not married? And that's it. So like I said, you could be married for a minute and you're married and your spouse has rights. Oh, and I should go back to, so not only, so that they automatically get a life estate. That happens automatically, nothing you can do about it, it happens. Alternatively, they can make an election within 6 months of the person's death to take a 50% interest in the property in lieu of the life estate. So they get 50% and then the children would get 50%. And it's as a tenant in common interest, meaning the spouse owns his or her share, the kids own their share, they're not connected, there's no right of survivorship or anything like that. And the significant benefit of doing that is that either side could file a partition action with the courts to sell the property, to force a sale of the property, where traditionally when we only had the life estate with the remainder interest, those people were all stuck with one another unless they could come to some sort of agreement what to do with the property. And that resulted in a lot of disastrous situations. Sometimes you'd have a spouse, not paying the mortgage or not keeping the property up, or not being able to afford, the property. And unless the spouse and the children got together and came to an agreement to sell and how to split up the proceeds, it was just a big fat mess. So about probably 11 years ago, I think the law was changed where they added this election that can be made to take a 50% interest instead. So at least that gives you either side that right to force the property to be sold, which you don't want to ever be in that situation because it costs a lot of money to go to court and do that. But at least you have that remedy. But it is a hard deadline, 6 months after death, period. There's no extensions. There's no, I didn't receive notice. It's 6 months after death, and that's it. So what I oftentimes see is I might, have somebody come to me and their spouse passed away, but they were not aware of this rule. Maybe there was no probate administration necessary. So nothing ever happened in the courts, nothing ever happened. And they didn't make the election. They didn't know they could make the election because they had no need to seek legal guidance at the time. So it's good for people to know that this option is out there, because if the situation ever happens, you need to know that you need to file that election within 6 months.
Wow, that's a lot to take in. Well, let's, on the similar topic, I'm married for the first time. My spouse, again, is still, not on the title of the house. What happens when I die if I don't have a will or a trust? And I do have a second part to that as well. If I do have a will or trust, can I leave the house to my spouse?
Okay, so first part, if you have no documents, you die what's called intestate. And if your spouse is not on the title to the property, even if your children are from your marriage and neither party has a child outside of that marriage, the spouse still gets the life estate with the remainder to the children. So you could have a situation where husband and wife are living, or husband and wife, whatever, are living in this property for their entire lives, and for various reasons, one spouse might not be on that title. There's lots of different reasons why that happens. And they are really surprised to find out that the surviving spouse doesn't own the property anymore 100%. It's very, very shocking. And if you don't get along with your kids, or one out of, if you have several kids and you don't get along with them, that can obviously be really, really problematic. Or if, let's say, one or more of your kids has financial problems, or they're disabled or incapacitated, the title has now vested in them, the remainder interest, but it's still a current interest in a sense in that property, and you can't do anything with the property without the consent of those kids. So it really catches people off guard and can be a real problem. And then your second part to that question was, can you do something about that, with having a will or a trust? And it depends. So if there are no minor children, yes, you can devise your homestead to your spouse, either in a will or in a trust. If you have minor children, though, you cannot. So I had a situation where we prorated an estate and the husband died. He had a will. He left the house to his wife. Well, they had a minor child, so that devise was invalid. So then she ended up with a life estate with the remainder to not only a minor child, which is a problem because, now we have guardianship issues, but the husband had children from a prior marriage. And this lady didn't even know these kids. They were adults. She never even met them. So it was pretty disastrous as well.
Wow.
So
I do have a question from the audience, Samantha. What is there? Okay, I'm going to do it the best I can. What if there is a due on sale clause on a property and the mortgage is in the decedent's name?
yeah, that's an issue. So when an owner of a property dies and there's a mortgage, it's going to trigger the due on sale clause because there's technically a transfer there. Does the mortgage company do anything about it? Usually not, as long as you're paying the mortgage. They don't even know, nor do they probably care, as long as they're getting paid. But it kind of raises just a more general question or problem in general. When somebody dies and there's a mortgage, you got to do something at some point. People think that they can just, keep it the way it is and keep paying it. And sometimes that's a strategy if there's not a better solution. So sometimes people can't afford to pay off the mortgage, or they can't qualify to refinance the property. And they want to keep it. Maybe they were living in the property, maybe they were taking care of mom or dad, or it's their spouse. So there's some practical issues and problems that arise there. But generally speaking, yes, the due on sale, the clause is going to be triggered. The mortgage should be paid off. You should either refinance or pay it off with other assets, or it's going to be sold, and then of course the mortgage paid off then.
Okay, I hope we answered your question. That was great, Samantha. Okay, so I heard that I shouldn't put my house in my revocable trust. Is that true?
So I'm a big believer of putting the property or your primary residence in your trust. There are some lawyers out there that don't do it. I think it tends to be the older lawyers that maybe weren't used to it. At years and years and years ago, there was some question about, does it cause problems? Those issues have all been eliminated. There's really no downside to putting it in your trust. There's only upside. Can there be problems? Yes, but not associated with the trust. It's going to be the substance of the homestead problems that we have in general. Homestead's tricky. It has lots of rules. There's spousal rules, there's minor child rules, there's just rules in general. So the trust isn't necessarily going to cause any problems, but you may not achieve what you're trying to achieve just because you put it in the trust. for instance, if you put it in the trust and, you know, you're trying to leave it to your children, but you have a spouse. Well, it's not going to avoid the rules just because you put it in your trust. So it may end up having to come out of the trust and going through probate anyway, because you didn't follow the rules. But absolutely, I put all my clients' home primary residences in their trust. The plan is to avoid probate. I see oftentimes I'll administer estates where they did a good job with the estate planning and they did a really good job funding their trust, and almost all of their assets didn't have to go through a probate administration, except their home. So for whatever reason, the lawyer didn't believe in putting the home in the trust. So now we're doing a probate just for the home, which, you know, it's great for me. It's more business, but, you know, had they just done a deed and put the home into the trust, they would have completely avoided probate and cost and expense and time. You know, it takes time to go through the court process. So, yeah.
Well, just to make sure we were thorough, there is a question from the audience, and it says, if I have a will, does my house have to go through probate?
Absolutely. A will does not keep anything out of probate. All it does is control that process once you're there. So I get a lot of questions from people in general. Well, he or she had a spouse, so does it just pass to the spouse? No. Well, he or she has a will, so the will says that so-and-so gets it. Okay, but, you know, to effectuate that will, it has to go through the probate process. So a will is good, but it's not the only thing that you should have. And people should take some steps to try to avoid probate.
Sounds like a plan, because yes, the court system, especially now, is so tied up. It is so crazy. And I have another question for you. I think we kind of covered it, but, you know, maybe you find a caveat in it. Someone's on their second marriage and they'd like to leave the house to their wife so that they can live in it for the rest of their life, as long as they live. And then, though, they want their wishes to have it passed to the children. Is there a way that they can actually do that?
So it's interesting because under Florida law, you know, the spouse automatically gets a life estate with the remainder to the kids. So one would think that you could do that in your documents, say, oh, I want to put my house in the trust so it doesn't go through probate, and I'm going to give my spouse a life estate with the remainder to my kids, just like he or she would get under the law of Florida. But it doesn't work. Who knows why? But it doesn't. It's the law doesn't allow that. So you, assuming you don't have minor kids, because if you have minor kids, you simply can't give your homestead to anybody. But if you don't have minor kids, let's say they're all adults, the only thing you can give your spouse is 100% fee simple interest in that property. That's the only valid devise. You cannot put any sort of restrictions or caveats on that devise to the spouse. So even though what you're giving them is what they would get under Florida law, doesn't work. So you either give them 100% in the document and then it's fine, or if you want to give them something different, they have to waive their rights. So all of these things can be waived by the spouse, and that either happens in a prenuptial agreement, in a postnuptial agreement, or what I call the waiver of death rights. So rather than do a full-blown pre or postnuptial agreement, you can just waive your rights that are associated with death, because there's more than just homestead. There's elective share. Those are really the two biggies. There's the homestead rights and the elective share, and then there's some smaller things. But you can waive those rights. It has to be in writing. If it's done after the marriage, you have to disclose your assets. And even if it's before the marriage with the prenuptial agreement, it's recommended to disclose your assets so that the spouse knows what they are waiving, you know, what benefit they're waiving. It's always good to have separate lawyers representing each spouse so that the spouse can never come back and say, I didn't understand what I was doing. I was coerced into doing this, blah, blah, blah. Obviously, that adds to the expense and the complexity of it in general, because once you have more than one lawyer, you know, everything becomes more complex. But it is for the client's benefit, for each party to have their own lawyer.
So I think you got some of our listeners nervous because I've got a couple of these questions that are identical. So what's the best way to avoid probate?
Not to get married.
No,
Don't get
probate and
married
married,
again.
no, what's the best way to avoid the homestead issues is not to get married. It is true though. I mean, you joke, but it's true in a sense of, if you're getting married later in life, or it's a second or third or fourth or fifth marriage, if you have children from a prior relationship, go get some legal advice before you get married. There's, aside from, your homestead rights, as I said, there's elective share, which is 30% of everything that you own, basically. There's, alimony and, other marital asset divisions. There's all sorts of things that are gonna potentially happen. So definitely go get some legal advice. The best way to avoid probate is the use of a trust. That's, number one. Beneficiary designations are good. A trust is better. But any financial account that names a beneficiary, that account will not go through the probate process. It will go directly to the beneficiary. So that's good if all is good with that beneficiary, assuming they are not disabled or incapacitated. They're not going through a divorce. They're not going through a bankruptcy. They're not getting sued. They're not doing drugs. They're not a minor. So beneficiary designations are great. Oftentimes we utilize that in conjunction with the trust. So we do a trust, and maybe the trust is the beneficiary of the financial account. But a trust is, I'd say, like the number one way to avoid probate and have significant protections for your beneficiaries.
Hey, awesome. Hopefully people are calm. We talk a lot right here about married people, but a single person that has property and assets, is it a good thing for them to, protect themselves right up front before a marriage or anything like that on the single person scale?
In general, for doing estate planning, yeah, every person should really have some basic documents in place, your healthcare advance directives. So you appoint somebody to make healthcare decisions for you. Financial directives, a durable power of attorney, so somebody can make financial decisions for you. Everybody should have at least a basic will in place, especially if you're not married or you don't have kids. Who gets your stuff? There's lots of millennials out there that are, making a significant amount of money. They're not married. So what happens if they die? And, sadly, people die. People die in car accidents. They die from illnesses. They get murdered. Things happen. People die unexpectedly. And young people tend not to be prepared. Oftentimes it's either your age that springs this into motion, or it's having children, which is good. Those people should definitely be prepared. But those people who are single and they don't have kids, but they're young professionals, they have assets, they have money. And they don't really think about, any of these things. And it's not just if you die, what happens to your stuff? It's while you're alive. If you're incapacitated, who can make medical decisions for you? Who can make financial decisions for you? Who can pay your mortgage if you're in a bad car accident? Who can pick up the phone and talk to your mortgage company or your credit card company or your health insurance company? Who can maybe get those benefits from your AFLAC policy, that you got at your job? These are definitely things that people, as soon as you turn 18, you're an adult. These are things that people need to think about. And one thing we didn't really talk about before is, with the homestead, if you don't have children, you can do whatever you want with your property to your spouse. At least you can leave your spouse that property, and there's no restrictions on that. There's still the same restrictions. Like, I've had some people before me that say, I don't really like my spouse. I want to leave my property to my friend or my brother or my sister or my cousin or whomever. Can't do it. And what's interesting, here's a little tricky scenario. I've had instances where, second marriage, both parties, both spouses, before they get married, have their own property. They each live in their own house, right? Then one moves in with the other. So where they live now is their primary residence. That's the homestead. The other property is no longer your primary residence. There's no restrictions on it. Even though you're married, even though you have minor kids, let's say, you can do whatever you want with non-homestead property. You can leave it to your friend or your cousin or your caretaker or whomever. But then the one that you live in is the primary residence. So I've seen inequities where, you know, the one spouse left the property to whomever they wanted to, and the spouse that moved into their property, you know, kind of got the short end of the stick. You still have the elective share, of course, where if you try to completely disinherit your spouse, the spouse can still take 30% of all your assets. But that's, you know, less than a life estate or 50% of that homestead. So as I say, homestead is tricky. We have some really tricky rules with that, all that creditor protection.
Well, I don't know about you all, but I learned so much today, and it was really eye-opening in so many ways. So before we close, I would love to see, does anyone have any questions that you want to come on voice or camera versus the chat box? You know, some of us may not, you know how to use that. Anyone, just raise your hand. Well, if not, I want to thank you all for coming today. I want to remind you that we're here every Friday, third Friday of the month from noon to 12:30. This is purely an educational program to get you either excited or moving so you can get your you know what together. And because you've come to see us today, as always, you can pick up the phone and call Samantha's office. She'll be happy to answer any questions you have or to have a brief consult with you. But she is so open and welcoming. Samantha, I want to thank you so much for your time today. You were very, very insightful. We've got people typing in there. I'm actually shocked. I learned so much. So please stay tuned and come in. This is our 4th program. Next month will be our 5th. And we are so excited. It's a new topic every time. So again, would you like to say some parting words, Samantha?
Well, thank you, Bianca. Really appreciate you moderating. It always makes it a lot more fun. Thank you, everybody, for coming. This is super exciting. And I told you Homestead was exciting, right? It's very, very tricky and exciting. Lots of other great topics. If you missed any prior ones, you can go to my YouTube page, and we've recorded them, and we've blurred everybody's faces out. So there's no issues there. Don't be nervous. They'll be on camera. But you can see our prior topics. We've talked about healthcare surrogates and disinheriting your children and spouses and durable powers of attorney. So feel free to go back and check those out. And each month we'll have a different topic, new and exciting, very exciting estate planning topics.
Well, again, have an awesome Friday. Start your weekend out great. And one last word, it's not snowing in Florida.
Yeah.
Yay. So have a great weekend, everyone. And thank you so much for coming.
Bye, everybody.
Signing off.